5 gun law updates are locked and loaded for 2026, and every single one of them is going to change something real about how you carry your concealed firearm every day. And at least 2 of these updates are going to hit gun owners who think they are already fully compliant completely out of nowhere. Here's the reality that most gun channels are not telling you. The concealed carry rules that kept you legal in 2025 may not keep you legal in 2026. And the worst part is that the gun owners most at risk are not the careless ones. They are the responsible, experienced carriers who checked the rules once, felt confident, and stopped checking. That is the profile of the person who gets caught. And I do not want that person to be you. Here is what I am asking you to do right now before we go one word further into this video. Hit that subscribe button. Join the community of over 50,000 gun owners who get these updates first, so they are never the last to know when the rules change. Do it now. Then let us get into these 5 updates because the clock on some of them is already running. So let us start with the first update, and the reason I am leading with this one is that it affects every single concealed carrier in America, regardless of which state you live in. The first major update coming in 2026 involves changes to how the federal background check system, called the National Instant Criminal Background Check System, or NICS, processes and flags certain records. Now you might be thinking, this sounds like a dealer issue, not a carrier issue. Stay with me, because this affects you directly, even if you already own your guns and carry every day. Here is what most people do not know. NICS is not a static frozen database. It is constantly being updated. Records are added, records are corrected. And sometimes, records that should not be there end up in the system for people who are completely law-abiding. The 2026 updates include new data sharing agreements between federal agencies and state databases that are going to result in a significant expansion of the records feeding into the NICS system. For the vast majority of gun owners, this will not matter. But for a meaningful number of people, new records connected to things like old civil court proceedings, certain medical interactions, or administrative legal matters are going to appear in the system for the first time in 2026 that were never there before. Here is why this matters for someone who already carries legally. If a record that disqualifies you from firearm possession appears in the system, you do not get an automatic notification. You do not get a warning letter. The system gets updated and you continue carrying, not knowing that your legal status may have changed based on information you have never even reviewed. The 2026 NICS expansion makes it more important than ever for every responsible gun owner to periodically verify their own background check status. Many states offer a process through which you can submit your own information for a voluntary check. This is something worth doing before the new data integrations take effect in 2026. Let me give you a concrete example. Suppose you were involved in a civil restraining order proceeding 10 years ago. That proceeding ended without any finding against you, and you assumed it was behind you. Under the 2026 data expansions, some states are now sending old civil docket information to NICS that was never shared before. If the record is incomplete or incorrectly classified, it could flag as a disqualifier even though you're fully eligible. You would have no idea. Then you go to buy a new firearm or even just get pulled over and the officer sees a hit in the system. That is a nightmare scenario that is completely avoidable if you proactively check your record. Here is something I want you to think about right now. I am building a complete follow-up video specifically on how to verify your own NICS status, what to do if you find an error, and how to challenge incorrect records before they create a legal problem you never saw coming. Subscribe right now so you catch that video when it goes live. The process has specific steps and specific deadlines, and you need the full picture to navigate it correctly. Now let us move to the second update, and this one is going to directly affect your carry situation every time you cross a state line. The second major 2026 update involves significant changes to concealed carry reciprocity agreements between states, and the direction these changes are moving is genuinely surprising to most gun owners who have not been closely watching. You would expect that with the growing constitutional carry movement, reciprocity would be getting broader and simpler. In some ways it is. But in other specific ways, the situation is actually getting more complicated for certain groups of carriers. Here's what is happening. As more states move to constitutional carry and drop their mandatory permit requirements, a subset of other states that maintain reciprocity only with states that require training and background checks for permits are now reviewing whether their reciprocity agreements with newly constitutional carry states still make sense under their own state laws. Some of those states are quietly suspending or modifying reciprocity arrangements without making major public announcements. The gun owner who checked their reciprocity map 2 years ago and has been driving across state lines with confidence is exactly the person who could unknowingly end up carrying illegally in a state that used to recognize their permit but no longer does. Because the agreement was modified during a legislative session, nobody was watching. Let me give you a real-life scenario. State A used to require a permit to carry. State B recognized State A permits. Then State A passed constitutional carry and made permits optional. State B then decided that it would only recognize permits from states that still require permits for all carriers, not optional ones. So State B quietly updated its reciprocity list, removing State A permits. You live in State A, you have a voluntary permit, and you drive into State B. Under State B law, you are now carrying illegally because your State A permit is no longer recognized. Nothing changed about your permit. The law changed. And you had no idea because State B did not send you a letter. You only find out when you get stopped. The second reciprocity complication coming in 2026 involves some states adding new training or documentation requirements as conditions for recognizing out-of-state permits. Even if your permit is still technically on their recognized list, you may now be required to meet additional standards to legally rely on that recognition. This is a genuinely new development that most concealed carriers are not aware of because it is not being communicated directly to permit holders by the states involved. For example, a state might now require that your home state permit include proof of live fire training. If your permit does not include that proof, even though it is valid in your home state, it may not be recognized for reciprocity. You would need to carry additional documentation or obtain a different permit. Now, quick legal note right here, and this is important. Everything in this video is educational information only. It is not legal advice for your specific situation. Reciprocity laws, NICS processes, and all of the other updates I am covering here are highly state-specific and are actively changing. The general information I am providing gives you a framework for understanding what is happening. For guidance on how these specific changes apply to your specific permits, your specific travel routes, and your specific legal situation, please consult a licensed firearms attorney in your state. I mean that sincerely. These details matter, and getting them wrong has real consequences. But wait, there is something even more important that connects the first two updates I just covered, and it leads directly into the third update. The common thread running through next changes and reciprocity changes is that they both create situations where your legal status changes without you receiving direct notification. You are legal today, something updates in a database or a state agreement, you're now in a legal gray area or outright illegal tomorrow, and you have no idea. The third 2026 update is directly related to this notification gap, and it involves new red flag law enforcement mechanisms that are coming online in multiple states in 2026. Red flag laws, which are also called extreme risk protection orders, allow courts to temporarily remove firearms from individuals based on concerns about danger to themselves or others. These laws exist in a growing number of states, and they have been expanding both in scope and in enforcement capacity. The 2026 updates in multiple states involve new automated systems and expanded categories of people who can file red flag petitions. Some of these expansions include employers in certain regulated industries, healthcare providers in certain situations, and school officials in certain contexts. The expansion of who can file a petition means the number of people exposed to potential red flag proceedings is growing significantly. Here is what most gun owners get wrong about red flag laws. They think it only happens to people who have made obvious threats or who are visibly in crisis. The reality is that the legal standard for initiating a red flag proceeding in many states is lower than most people expect, and the initial order, removing your firearms, can happen before you have a meaningful opportunity to respond. The time-sensitive nature of your rights in a red flag proceeding is one of the most critical and least understood aspects of these laws. In most states, once a red flag order is issued, you have a very short window, often just days, to request a hearing and present your case. Miss that window and the order may be extended significantly. If you are ever subject to a red flag proceeding, knowing your rights and acting on them immediately is not optional. It is the entire ballgame. Let me give you a hypothetical. A neighbor who does not like you files a petition claiming you have been acting aggressively. Under the new automated systems in some states, a judge may issue a temporary order based solely on the petition without hearing your side, and law enforcement shows up at your door to take your firearms. You now have 10 days to request a hearing. If you do not know that deadline exists, or you think it will just go away, you will lose your firearms for months. If you do know and you act immediately with an attorney, you may have them back within weeks. That is the difference between knowledge and ignorance. That is why this update matters so much. Hey, real quick. I know there are a huge number of people watching this video who are not subscribed yet, and I want to say this plainly. The three updates I have covered so far, NICS changes, reciprocity modifications, and red flag expansions, are all active moving situations that are going to keep developing throughout 2026 in ways that require ongoing awareness. Not one-time awareness, ongoing. That is what this channel provides for over 50,000 gun owners who have already subscribed. Do not be one of the people who finds this video once, gets the information, and then misses every follow-up development. Join the community right now, click subscribe, and turn on notifications. The fourth major 2026 update involves prohibited location laws, and this is one where I see the most dangerous overconfidence among experienced concealed carriers. Most carriers who have been doing this for a while feel like they have a solid, reliable mental map of where they can and cannot carry. They checked the list when they first got their permit. They updated it when they moved or when a major law changed. And now they feel confident in their knowledge. That confidence is exactly what makes this update so dangerous for experienced carriers, because prohibited location lists in multiple states are being actively modified in 2026 through both legislative action and court decisions. And the changes are not always in the direction you would expect. On one side, courts applying the Bruin historical tradition test are finding that some previously prohibited locations cannot legally be off limits because there is no historical basis for prohibiting firearms there. This is good news for gun owners, but it creates a temporary complication. Just because a court has found a prohibition unconstitutional does not mean it is instantly gone everywhere. Until your specific jurisdiction formally recognizes the ruling, you're in a gray area. On the other side, some states are actively adding new categories to their prohibited location lists in 2026 in response to political pressure, and those additions are taking effect on specific dates that many carriers are going to miss. The interaction between court-ordered removals of prohibitions and legislative additions of new ones is creating a rapidly shifting prohibited location landscape that cannot be navigated safely with information that is even 6 months old. This is not a one-time check situation. Staying current on your state's prohibited location list is something that needs to happen at least twice a year in the current legal environment. Let me give you a concrete example. In one western state, a federal court recently struck down a ban on carrying in public parks. That ruling is binding only within that federal district. In the same state, the legislature passed a new law banning carrying in all sporting events, including amateur youth sports in public parks. So now, in that district, you can carry in the park, generally, but if there is a soccer game happening, you cannot. And the boundary of the sporting event is not marked. How do you know if you are within the prohibited area? You have to know the exact definition under state law, which changed in 2026. This is not simple. This is not something you can memorize once. You have to stay current. The fifth and final 2026 update is the one with the broadest long-term implications and the one that is going to reshape concealed carry in America for years beyond 2026. The fifth update is the continuing and accelerating expansion of constitutional carry states and the cascading legal and practical effects of that expansion on the entire concealed carry ecosystem. As I mentioned, constitutional carry means carrying without a permit requirement for those who are otherwise legally eligible. The number of constitutional carry states has been growing steadily for years, and multiple additional states are on track to join that group through 2026 legislative action. Here's the part that most people miss about what this expansion actually means for day-to-day concealed carry. In a constitutional carry state, the baseline legal question of whether you need a permit to carry is answered simply. You do not, assuming you are legally eligible to own a firearm. But the complexity does not disappear, it shifts. In a constitutional carry state, the burden shifts from proving you have a permit to proving you're legally eligible in the first place. And for people who have anything in their background that creates any question about legal eligibility, that shift in burden is not a simplification. It is a more complex situation because the conversation with law enforcement during any encounter becomes more detailed and more legally nuanced rather than less. Additionally, as I noted in the reciprocity discussion, carrying voluntarily obtained permits, even in constitutional carry states, remains strategically valuable for travel purposes. The interaction between constitutional carry expansion and reciprocity complexity means that 2026 is simultaneously the most freedom expanding and most legally complicated period in the history of American concealed carry. And navigating it safely requires exactly the kind of ongoing, current, accurate information that most gun owners are not getting from mainstream sources. Let me give you a practical recommendation for constitutional carry states. Even if you do not need a permit to carry in your home state, get one anyway if you can. Use it for travel. Keep it active. It gives you reciprocity in states that do not have constitutional carry, and it provides the federal exception to the Gun-Free School Zones Act. A permit is a tool, not a burden. In 2026, that tool is more valuable than ever. The 5 updates I just walked you through are all actively moving right now, and they are going to keep developing throughout 2026 in ways that matter for your daily carry decisions. The NIX expansion, the reciprocity modifications, the red flag law growth, the prohibited location changes, and the constitutional carry expansion are all connected to each other in ways that create a complex but navigable landscape for the informed gun owner. The key word there is informed. Subscribe right now because the next video I'm releasing goes deep on the state-specific details of every one of these 5 updates, with a practical action checklist for concealed carriers to work through before the end of the year. That checklist has real timing attached to some of its items. Do not miss it. Here's the bottom line that every concealed carrier needs to walk away with today. 5 significant gun law updates are reshaping the concealed carry landscape in 2026. Your background check status can change without notification and should be periodically verified. Your reciprocity access may have changed since you last checked and needs to be verified before every interstate trip. Red flag law expansions are creating new exposure for more people in more situations, and knowing your procedural rights in those proceedings is critical. Prohibited location lists are shifting in both directions simultaneously and cannot be safely navigated with outdated information. And constitutional carry expansion is creating new freedoms and new complexities simultaneously. The responsible concealed carrier in 2026 is not the one who learned the rules once. It is the one who stays current. Share this video with one concealed carrier in your life who needs this information right now. And subscribe to this channel because we are going to be here tracking every one of these 5 developments and bringing you the updates you need to stay legally protected as they unfold. One final and essential reminder: everything in this video is for educational and informational purposes only and does not constitute legal advice. Concealed carry laws vary significantly by state and are actively changing. Always consult a licensed firearms attorney in your jurisdiction before making decisions about your carry practices, your permits, or your legal rights. Stay informed, stay legal, and stay safe.